Here is the exact text you provided. Investigation is the most important phase in a criminal case. Criminal investigation is responsible to prove guilt of accused beyond reasonable doubt. An accused is presumed to be innocent and cannot be convicted in absence of trustworthy, confidence-inspiring evidence. This high standard of proof can only be achieved if evidence is properly collected, secured, and documented at stage of investigation, so that it can later on be produced in court to prove charges against accused. Its importance can be estimated from the fact that any evidence either not collected by investigating officer or not collected in accordance with the prescribed law and rules can directly affect the result of trial. Courts in any criminal justice system are not involved in collecting evidence. It is the exclusive domain of investigating officer, IO. Functions of court are to draw inference from evidence and then conclude either an offense has been committed or to give judgment that a particular person is not guilty. Defining investigation. Criminal investigation is defined as the collection of information and evidence for identifying, apprehending, and convicting suspected offenders. In legal terms, investigation includes all the proceedings for the collection of evidence conducted by a police officer or by any person who is authorized by a magistrate in this behalf. A good investigation is a rigorous process that consists of identification, collection, preservation, and presentation of evidence in court of law. Investigation means scrutiny, search, or an inquiry into a matter to find out truth, to know about facts, or solve a crime case. Investigation is a multidisciplinary approach, involves systematic and logical thinking, requires minute and detailed inspection, includes observation, examination, and fact-finding inquiry of witnesses, is a rigorous quest for inculpatory or exculpatory evidence. Difference between investigation and inquiry. The Code of Criminal Procedure 1898 draws a distinction between investigation and inquiry. Section 4.1 of the Code defines investigation as, investigation includes all the proceedings under this code for the collection of evidence conducted by a police officer who is authorized by a magistrate in this behalf. Section 4K defines inquiry as, inquiry includes every inquiry other than a trial conducted under this code by a magistrate or court. Goals of investigation. 1. To recognize evidence. This is done by a detailed survey and research of the crime scene. Everything present on a crime scene may or may not have a probative value. An investigator must be able to recognize what evidence can be helpful and what should be collected. 2. To collect evidence. Most crime scenes involve massive physical evidence that can be collected by the investigator to be later produced in court, e.g., empty cartridges, DNA, fingerprints, and other trace evidence. Evidence must be labeled properly, describing FIR number, nature, type of evidence, position and place of its collection, time, date, and name of witness in whose presence such evidence was collected. 3. Preservation of evidence. Preservation is as essential as collection because if the integrity of evidence is compromised, it cannot be made the basis for conviction. To achieve this, the chain of custody must be maintained, which is a chronological log of handling of evidence from its collection to its presentation in court. 4. Documentation of crime and other proceedings. Recording of witness statements. Statements must be recorded at the crime scene, and witnesses should be separated to avoid fabrication. Crime sketch. Scaled or unscaled sketches must show important landmarks, positions of accused, and witnesses if any. Photography and videography. Modern techniques include capturing the crime scene from various angles. First inspection. Note a detailed note of the first inspection. Preparation of inquest reports includes injury statements in cases of murder,